favorable wind brought her to the University of Leuven, where she finished her PhD, and for a short while we had the pleasure of being colleagues. Now she's currently a senior lecturer at University of Antwerp. She's teaching private international law, comparative and European civil procedure, and comparative family law. She's also an author of numerous publications in these fields of law, and I'm very happy that we have her here today because she's an excellent teacher. Professor Kruger, you have the floor.
Thank you very much for those kind words. Thank you to the EJTN for inviting me to speak here to you today. It's always the worst session is the one right after lunch, right? So if you get bored, just wave or ask a question, or if I speak too fast or slow, please do not hesitate to interrupt me. Okay. So our topic for this afternoon is parental responsibility, including international child abduction, but only the civil law aspects, of course, of international child abduction. We're not going to look at the criminal law issues because I don't know anything about that. Okay. Oops, that was what's going on? Okay. Those slides are different, but now they're the same. All right. Okay. Yeah, now it's all right. I'm sorry. So our two topics, parental responsibility and child abduction. For both, we have an EU instrument and an international instrument. Brussels 2A, the European instrument that you've already heard about this morning. But we also have these Hague Conventions. And these Hague Conventions are enforced in all EU member states. And they work together with the Brussels 2A regulation. So we'll see how they actually interact, because you have to apply them on top of each other. Okay, so we're starting with parental responsibility. We're going to look at the legal texts, what each of them have as scope, the jurisdiction, applicable law, recognition and enforcement, that kind of general basic structure of all private international law instruments. And then I'm briefly going to look at the Brussels 2A recast. Now, you have already heard about it this morning. I will only point you to certain changes that we can expect. The last knowledge that I have of this is that it will be considered by the plenary session of the European Parliament on the 15th of January. Parliament is not the big problem here, but it's Council, right? Because all EU member states have to agree. So the big debate is going to be there. And I don't really know what their time frame is. I've heard that they're introducing many changes, but let's see. So the legal text. First of all, let's start with the EU instrument. This is this Brussels 2A regulation. Sometimes it's called Brussels 2 bis, Brussels 2A, it's the same thing. It is obviously enforced in all EU member states except for Denmark, but you've heard all of that this morning. Then in the EU, we also have the EU Charter. Now that Charter is applicable whenever EU law applies to the EU law, to the European institutions, but also to the member states when applying EU law. Okay, so you'll see that the Charter contains many of the same provisions as the European Convention on Human Rights, but their scopes are a little bit different, okay? Because the European Convention on Human Rights is enforced in all the member states, all Council of Europe member states, but they always have to respect those, okay? Also when applying national law, whatever. While the EU Charter is only applicable in the sphere of EU law, okay? Then international. Tell me if you have any questions, huh? If you don't agree or anything? No? Okay. So the International Child Protection Convention is a very broad convention on jurisdiction, applicable law, recognition and enforcement, and cooperation in matters of parental responsibility and measures for the protection of children. Okay? The 1980 Hague Convention is specifically on the civil aspects of international child abduction. That's the return mechanism. So the child must be returned. Okay? And then internationally also, we should not forget the UN Convention on the Rights of the Child. That convention, as you know, is in force in all EU member states, almost the entire world, except for 2 countries, really. It always has to be applied. Whenever we have cases where children are involved, we have to take into account their rights to be heard, their rights to have their best interests being taken into account, their right to have contact with both their parents, their right not to be abducted. So all of that is part of the framework. Then we're going to start with Brussels 2A. You already know what it is about. That's the blue part of the slide. The red part of the slide is what is not under Brussels 2A. The exercise of state authority. Not civil status. By this we mean at what age does a child become independently capacitated, right? In most member states it's 18, but not all, and not for all situations the same. But that does not fall under Brussels 2A. Parentage, so the question of fatherhood, motherhood, the fact of whether you can establish parenthood outside of marriage, that is not governed by Brussels 2A. A different question that is governed by Brussels 2A is the parental responsibility. Okay, because those 2 things don't always go together, of course. You can be the legal father of a child without having parental responsibility. Okay. Maintenance, there we have a separate regulation. Okay. So, the same logic applies to the Hague Convention of 1996. It's parental responsibility. But it does not deal with child abduction, because for that we have the separate convention. It's also civil law, so not state authority. It does also not deal with civil status parentage, name, maintenance, social security, public measures of a general nature. Those public measures of a general nature, that relates to, for instance, health policies. For instance, an obligation that children must be vaccinated against certain diseases. That's public health policy. That would not be governed by the Hague Convention. Okay. So let's just look at these 2 next to each other, how they interact. Brussels 2A in force in 27 states, the Hague Convention in 47 states, all EU member states and a number of other states. Brussels 2A governs jurisdiction, recognition and enforcement, and cooperation. It does not govern applicable law. So for applicable law, we have to move to the 1996 Convention. Okay. The 1996 Convention, as I've said, deals with all 4 aspects. So then the question becomes, when do we use which one? Right? So for this, we have a provision in each of the instruments to tell us how to disconnect them. So in the area of jurisdiction, we look at the habitual residence of the child. Okay, that's my attempt at making a little house. So we see, where is the child habitually resident? If in the EU, we're going to use the jurisdiction rules of the regulation. If in a contracting state that's not an EU state, take for instance Switzerland or Turkey, we're going to use that convention. If the child is habitually resident outside, then we will see we have specific jurisdictional mechanisms that we still might use on the basis of the presence of the child. Okay. So applicable law, only the convention, that's easy. Recognition and enforcement. And for cooperation, we're going to see where is the judgment from, or with whom do we want to cooperate. So which states are involved? Yeah. Obviously, if we want to recognize and enforce a judgment from France in Belgium, we're going to use Brussels 2A. If we want to recognize and enforce a judgment from Denmark, that's a trick question, because Denmark is not bound by Brussels 2A, even though it's an EU member state. So we're going to use the Hague Convention. Okay, for Turkey and Switzerland, we're going to use the Hague Convention. Same with the aspects of cooperation. You're going to hear more about cooperation tomorrow, so I'm just putting it there to give you the full picture. Okay. Now, child abduction. Here we also then have the interaction between Brussels 2A and the Child Abduction Convention, but I'm going to deal with that in the second session, in the second part of the presentation on child abduction. Sorry, it's a bit warm. The idea is that there's a neat fit between the 1996 and the 1980 Convention. 1980 is only child abduction, and all the rest, all the surrounding things, all the other jurisdictional elements are governed by the 1996 Convention, the Brussels 2A regulation, dealing with both. Okay. Brussels 2A, as I've said, deals with civil matters. Now, interestingly, the issue of the placement of a child is considered a civil matter for purposes of Brussels 2A. So it is the issue of, for instance, in the A case, what happened was there was a family that had gone from Sweden to Finland, but they were living in caravans, okay, Roma, living in caravans, and then they applied for social housing. And as they applied for social housing, the authorities became aware of the presence of these children in Finland, and they were not going to school. So the authorities are saying, okay, we need to do something here, okay? We need to place these children with a foster, because then they looked further and they saw that the children were possibly being abused by the stepfather. So we have to place these children in foster care. That placement is considered a measure of child protection or an element of parental responsibility and not just public law. Okay, so that would fall under Brussels 2A. The first C case is similar. The second C case, this one, was a situation where a child was going from one member state to another and was going to be placed there in an institution. Okay, the Brussels 2A regulation, like the 1996 Hague Convention, provides for such a mechanism where you place children. For instance, there are many German children placed in Portugal or in Italy. They're either placed with foster families there or in institutions there. That is also regulated by Brussels 2A. And there's a compulsory mechanism that you have to use to place those children. You can't just call the institution and say, can we send the child? No, you have to go through the competent authorities as regulated by Brussels 2A. Okay, that's what the C case said. Are there any questions at this stage? Okay. No questions? Right. Now, let's start then with the jurisdiction rules. Okay, we've done the scope. We go on to jurisdiction. The general rule is a very simple rule in law saying the habitual residence. But as we've seen in the exercise before, it can be quite difficult to establish where is the habitual residence. Now, the good and the bad news for you as judges is it's a question of fact. Okay? There's no definition in the regulation. There's no definition in the 1996 or the 1980 Convention. There have been calls to introduce a definition in the Brussels 2A regulation. That will not be done. The Commission has not proposed a definition, and I don't think Parliament and Council are going to try and draft one. So, yeah, you just have to look at the facts and then decide, as we've seen before the break. However, the European Court of Justice has given us some guidelines in 4 cases already, okay? And what the court has said is, okay, it's a factual element, but there are some factors that we can take into account, okay? And as Pietro Francina said before the break, the real issue is where is the social integration? Where is the center of this person's life? Okay, for children, the court said in the A case, that's the same A case as the children living in the caravan, okay? The court said we have to look at the duration, regularity, conditions, and reasons for the stay in this country. What nationality do the children have? Where did they go to school? Wasn't helpful in the A case because they weren't going to school. But that's a very important element for children, of course, is school, because that's really the center of their lives. the language they speak, and then more generally their social and family ties. Those social and family ties are also important because many of these cases, all of the next ones, there were situations where the children were not yet going to school, okay, because they were small. In Mercredi and the OL case, they were infants, so not going to school, so you can't use that element, and the child doesn't really have its own sports or whatever. Other elements that national courts have added to that is sports, the children's own relationships with peers, so friends, the child's doctor, where the child had been hospitalized or where there was medical care for the child. So all those kind of factors of integration. For an infant, that was a child of 2 or 3 months in the Mercredi case, the court said, okay, we're going to use those same factors, but we're going to look at the person on whom the child is dependent. In that case, it was the mother, because the mother had taken the child to the other side of the world. But yeah, the child is not integrated, him or herself, but with the mother and the mother's family. In the case of an unborn child, that's the last case, OL versus PQ, what happened here was the family lived in Italy, and then the mother, with the agreement of the father, well, the future mother, while she was pregnant, with the agreement of her partner, went to Greece, saying, okay, I'm going to give birth in Greece, I'll be with my family, and then I'll come back later. She didn't go back. And then the question was, where is this child habitually resident? Okay, so this is a question that was faced by the Italian court. Can we now say that the child is actually habitually resident here because it was the project of the family, but this was the intention, the common intention of the parents, that this would be the habitual residence. On the other hand, the child is in Greece. The child has never been in Italy. The court said you cannot have a habitual residence in a place where you've never been. Okay? So intention is an element, sure, the conditions and the reasons for your stay, but there has to be a factual element as well. This is quite controversial for child abduction cases, because there's a case by the French Court of Cassation who said exactly the opposite. Who said, but in that case it was a family that moved from the US to France. The mother came to France, she was pregnant with a second child, so she brought the first child. She actually went to France because her dad was ill. And then she gave birth in France. She couldn't fly back all the way, whatever, in time. So she gave birth in France, and then she never went back. And the French Court of Cassation was also faced with this question, where is the habitual residence of the younger child? Okay, the older child, you could say, was habitually resident in the US, but the younger one was the problem. And there the court said, well, it was the family project to live as a family in Michigan in the US. So that was the child's habitual residence. But unfortunately, the French Court of Cassation would now have to adhere to what the Court of Justice has said. The middle case, I'll come back to the CM case. Right. So general rule, habitual residence of the child. Easy rule, but you have to use these factors. Now we get to the exceptions, additions, corrections, all the other rules. First one is when the child moves legally, okay? So as in the case we had this morning, the father said, all right, it's fine that you move to Romania now, okay? Then the court that had given a judgment on a visitation rights and the situation of where the child will live and the visitation that goes with that, can amend that order, that contact order, within 3 months. Okay? So, for instance, the father saw the child every Wednesday and every Friday, for instance. Now they move to a different country. The father said, fine, you can move to a different country, but then we would have to change that contact order. I mean, I can't go and get the child every Wednesday and Friday, but then the child should come to my country every second weekend for the whole weekend, for instance. In that 3-month period, you can go to the court of the former habitual residence. After those 3 months, you have to go to the court of the new habitual residence. I have not seen any case law using this because I also think it's not very useful, because a contact order is really linked to the facts, of course, and the US judges know that better than I do. Okay, you write the contact order very specific. At such and such a time on Wednesday, every first Wednesday of the month, on such and such an hour, at such and such address. It's very specific. So it doesn't really make sense to go and change that for a child that's now in a different country and with a different address. So it would make more sense for the judge of the new habitual residence to do this. So it's a rule that's out there, can be used. I don't think it's used often. I haven't seen it. Then the more difficult one is if the child moves illegally. So in other words, if there's a child abduction. So one of the parents takes the children without the consent of the other parent. Then the jurisdiction does not shift. Okay. Even if the person argues, yeah, but the child now has a new habitual residence, you can't shift the jurisdiction because that was a wrongful or illegal move. Unless the left behind parent has agreed, or the child is resident in the new state for more than a year and there's been no request for the return. So that kind of also means that the left behind parent agreed in the end, or there was a non-return order. Okay. So this is to safeguard the child abduction rules. Okay, that's Article 10. Then Article 12 is the possibility of choice of forum. Okay, so the parents can agree, let's go to a particular court. But this is very limited. First of all, they can agree to go to the divorce court. Now, you've seen this morning that parents, for instance, living in Italy, but they both have, let's say they both have Bulgarian nationality, they can go to the Bulgarian court for divorce on the basis of their nationality, right? Their common nationality. Normally, that court doesn't have jurisdiction over the child matter, yeah? But they can agree. So if they didn't accept the jurisdiction of that Bulgarian court, and at least one of them has parental responsibility over the child, and it's in the best interest of the child, or it's in the interests of the child, then the Bulgarian court can also hear the child case. Okay? So it's quite limited. There is another possibility that is not connected to the divorce court. That is that another court, which has a close connection with the child, maybe the child's nationality, and the parties accept, we will take the case to the Bulgarian court, for instance, and it's in the interest of the child. Okay. These are the jurisdiction rules of the Brussels 2A regulation. But here, let's just make a sidestep to the 1996 convention. Remember I told you this 1996 convention also has jurisdiction rules. Okay? So now, for a child that's not habitually resident in the EU, but that's habitually resident, let's say, in Turkey, we can't use, we're going to use that convention. Just let's go with that for a moment, okay? Now, that convention also has that first option to choose, so you can choose the divorce court, but does not have that second option. So you cannot choose a court other than the divorce court under the 1996 convention. So it's quite important to see, okay, which convention or regulation am I going to apply, and then see the exact rules, yeah? Then I've said to you, what do we do with situations where the child is not habitually resident here, or we don't know where the child is habitually resident, the habitual residence of the child cannot be established, then the court of the place where the child is present has jurisdiction. This can also be used for refugee children, unaccompanied minors, even if they come to our country, but they don't yet have a habitual residence because they've just arrived. we can take jurisdiction on the basis of presence. Okay, this provision explicitly refers to refugee or internationally displaced children. And then lastly, we have residually the domestic law. So only if you can't use the Brussels 2A regulation, you can't use the 1996 convention, then you can only revert to your national law, domestic law. Yeah. Okay. We have seen also before the break, Pietro Francina, before the case study even, referred to Article 20 on urgent matters. Yeah. Now, in urgent cases, the court can take jurisdiction based on the presence of a person or presence of assets. Okay? But the presence of the person, which person, as Miriam de Hemtina said, well, you know, you have different people, so it doesn't specifically refer to the presence of the child. Then that urgent measure is taken. It automatically lapses when the court with jurisdiction on the substance, or the court of the habitual residence of the child, takes a protection measure on the basis of the substance. Okay, the debtor check case is the case where the court said, well, it's not only where the child is present, because in this particular case they didn't want the court to take the provisional measures because it was a child abduction case. So they said, yeah, but the father is not present here. What the debtor check case also said, which is very important, is that these provisional measures should not be used to circumvent a child abduction case. Okay, so we've seen Article 10, we've seen Article 8. So normally there's habitual residence at the jurisdiction goes with habitual residence. The mother then takes, it's most often the mother, you know that, right? In 70% of child abduction cases, it's the mother. So the mother takes the child to the Czech Republic. Then she's clever, or she got good legal advice from some shrewd lawyer and said, but go to the court immediately and ask for the right to stay there. The European Court of Justice said, well, you can't circumvent and try to then go and authorize your child abduction by quickly getting a provisional authorization to stay there. Okay, and here I think it's also very important for judges to be very alert. Okay, because obviously the mother is not coming asking a provisional measure saying, hello, I abducted my child, can I please have your temporary authorization? She's telling a different story, okay? And it's very important for judges to see, wait a minute, why is this child here? Doesn't have habitual residence, otherwise she wouldn't be using Article 20. Why is this child here? And is this not an Article 10 case? Okay, and if it's Article 10, you have to say, I'm sorry, I don't have jurisdiction, go back. Go back and fight your fights over there. Yeah? Right. Then the transfer of jurisdiction, I'm put in the slide to be complete, but if I understand correctly, this is one of the matters that you'll be discussing tomorrow. This is just to remind you that if there's a court that has jurisdiction, there's still a mechanism to place that jurisdiction to a different court, okay? So to transfer was also a possibility for a court to ask for transfer. So the rules are not 100% absolute. There is this mechanism. It is quite innovative because it comes from the 1996 Hague Convention, but before that, in civil law countries, we don't really have that idea of taking a case from one court and transferring it to another court in a different country. It is for exceptional cases, but it can be quite useful where circumstances have changed, right? And this is because, particularly, when we look at Article 8, right, we said that the court of the place of habitual residence has jurisdiction. But when? Habitual residence when? So you're the appeal court now already, maybe. What time is the relevant time? What do you think? What's the... Sorry? No, not necessarily an abduction case even. When they instituted proceedings to say we want a new, we're disputing about where the child will live. It's the moment of the institution of the proceedings. Yeah, that's the moment that you have to look at the habitual residence. Now, as we've heard, many courts are quite slow, and then they always go on appeal in these cases. Not always, but very often. So now we're 3 years down the line. Maybe the child is not habitually resident where it was habitually resident, but that's still the point of reference. It's the moment of the institution of the proceedings. Okay? Right. So Brussels 1 bis, 2 bis says, look at the moment of the institution of the proceedings. The 1996 Hague Convention says something different. Have you dealt with this 1996 Hague Convention? Yeah? Do you know what it says? Yeah. Jurisdiction moves. When the child moves, jurisdiction moves. So, if during the proceedings the child moves, you lose the competence and another court becomes the court with jurisdiction. Okay. So, in between these two rules, yeah, there's some disconnect there. Okay. So, then we also have Article 19. You've referred to Article 19 on parallel proceedings. The court second sees must wait, and the court first sees must examine its jurisdiction. And if it says yes, it has jurisdiction, the first court will hear the case. If it says no, it has no jurisdiction, the second court can take its case back up. Okay, that's the same as in divorce cases, so I don't have anything new to say here. Then we can move to the next step, the applicable law. And here I've told you, Brussels 2A doesn't have any rules for us, nothing in there. So we use the 1996 Hague Convention. And this 1996 Hague Convention is very kind because it says, just apply your own law. Lex fori, okay, so they come to you, they ask for a measure of protection, they ask for establishing the residence, contact order, whatever. They ask for a protection of the assets of the child. Fine. You've checked your jurisdiction, you have jurisdiction, you can take a measure according to your own law. It's very logical, actually, because in the most cases, remember, jurisdiction is based on habitual residence. Child is here, the measures will be taken here, will be executed here. Okay, very logical and easy. Also easy because we don't have to go and find foreign law because it will take us ages, and then we haven't seen how this website works. So you only... Okay, so even if it's easy, we don't have to apply foreign law. However, there is an exception if the case is more closely connected to another legal system. Then you can use that other legal system for specific protection. Okay. Then, obviously, there is also situations in which people don't come to court, which I didn't put on the slide because you're judges, right? But there are issues that arise without people going to court. For instance, when a child is born here today and the mother is Italian and the father is Bulgarian, okay, we have to figure out their parenthood according to the private and national rules. But then, do they have parental responsibility? Okay, let's say they're not married. Okay, does an unmarried father have parental responsibility? Well, that's different in different legal systems. And for that, you have to look at the habitual residence of the child at the moment this question arises. Okay? So, for instance, the father then goes and asks for a passport with a local authority. Does this father have parental responsibility? That issue is determined by the law of the habitual residence of the child. But that cannot change in the sense that, well, it can change, but it cannot go back in the sense that under Belgian law, so the child is habitually resident here, under Belgian law, an unmarried father has parental responsibility. No need for any extra court order or any administrative registration, nothing. You just have parental responsibility because you're the father. Finished. Okay? If this child and the family now moves to another legal system where it's not automatic, where he needs to be registered. That father will now not all of a sudden automatically lose the parental responsibility that he had on the basis of Belgian law. So that is something that you do need to know as a judge, because you're looking at your own law, but then you're saying, oh, but wait a minute, does this father have habitual residence? Does this father have parental responsibility? Habitual residence? Oh, but what was the former habitual residence? And maybe the father gained parental responsibility there and carried it with him to his new legal system, right? That's Article 16.3 of the 1996 Hague Convention. Is that clear? Okay, you'll ask me when there are questions, right? There is a specific protection for third parties with respect to the validity of transactions. So, for instance, we have a child who is an actor, okay? And he's acting in some show, and he's going to get paid for that. And a parent signs the contract on behalf of the child. Normally, the third party can accept that father or mother, whoever, had the authority, had parental responsibility, and was thus capable to act for the child. Okay, unless the third party knew or should have known what the law of the actual habitual residence of the child was. Okay, so there's a specific protection there for that third party concluding the contract with somebody on behalf of the child. The convention has universal application. You've heard this morning also with respect to Rome 3, right? So that means if we apply this convention and we come to the conclusion, well, South African law is applicable. South Africa is not party to the 1996 Hague Convention. We don't care. We're going to apply South African law anyway. Universal. We're always going to use it. It's quite easy, right? There is a limited renvoi. Okay, you know what renvoi is? Yeah, I see some recognition, some not. Okay. Basically, it means that we're going to take into account what are the private international law rules on applicable law of the other country. So, we can only use this, or we only need it. We don't want to use it, but we only need it when the question is the law of a non-contracting state, for instance. We say, okay, we have to look at the law of the habitual residence of the child in order to see whether this father had parental responsibility. Okay. The habitual residence is South Africa. Okay, I've told you South Africa is not a party to this convention. However, South African law says that we have to look at the law of the domicile, which is something particular in English law. It's not completely the same as habitual residence. So the child is habitually resident in South Africa, but is actually domiciled in Botswana, the neighboring country. Okay. Botswana law also says, well, look, we'll use the domicile. Which law are we going to apply? The law of Botswana. Okay. So we say we apply law of state 1. But law of state 1 says, no, we'll apply law of state 2. And law of state 2 also says, no, we'll apply law of state 2. So who are we to tell them what to do? So we're going to follow what they would have done and apply the law of state 2. Does that make sense? Okay, great. Then there's a public policy exception. That's quite general. We always have this. If we come to a legal system and we have to apply, that really contains a rule that we find contrary to our public policy. Some countries still have absolute rules. For instance, if the child is under 12, the child will be resident with a mother. Okay, and if we say, yeah, but in this particular case, we can't do that because it's just contrary to our public policy to force this child to go and live with a mother who is an alcoholic, who hits the child. So we're not going to apply that law. We're going to use our public policy exception and look at the best interest of the child and use our own law. Yeah? It's also, I mean, you know the concept of public policy. Right, then we get to recognition and enforcement. Now, recognition and enforcement, there are three regimes: the general procedure, then a special regime for access rights and the second chance procedure, and then another regime for provisional measures. Okay, so let's start with the general procedure. Recognition without procedure, like you've heard this morning, same rules. For exequatur, you would need a request for exequatur, and here there are cases that where you need exequatur. The difficult thing is actually doing the forceful execution of, actually taking the child from one parent and giving it to the other parent. There are limited grounds of refusal. There are these ones. They're similar to the ones on divorce, but not exactly the same. The public policy exception refers particularly to the best interest of the child. There's a specific rule on hearing the child. I'm not going to say too much about that because that would also be discussed tomorrow. There are rules, there's a ground for refusal that the rights of defense were not respected, in the sense that the defendant was not properly served with proceedings and didn't know in time that he or she had to go to this other court. Yeah, that's a ground for refusal. If the interested parties were not heard, and here we're talking about a person with parental responsibility, maybe an institution where the child had been placed, a grandparent, whoever, if there are conflicting judgments. Sorry, I have to say one more thing about the conflicting judgments, and that is that in parental responsibility cases, it is the latest judgment that takes precedence, not the first. Okay, and so in divorce, it's the first judgment that will be recognized and enforced. Well, recognized. In parental responsibility, it's always the last one, the last state of affairs, because the situation can change. Yeah. Okay, then exequatur was abolished for these two situations. If there's a contact order, it is automatically enforced or enforceable in all EU member states. And the second chance procedure, that has to do with child abduction, so I'll get back to that. I'm going to skip that. There are specific certificates. You can find those certificates. I put a link there, but you have the entire regulations. They're annexes 3 and 4 for the second chance procedures. Okay. This case, these cases actually all said that these certificates are very, well, they're just the truth. In the sense that if there's a certificate that says this judgment complies with all the requirements, then it has to be enforced. You cannot second guess a certificate. Okay, even though in the Aguirre Zaraga case, the German court said, yeah, but we're not going to enforce this because the Spanish court filled in the certificate wrong. No, cannot say that. The Court of Justice said you have to trust whatever the Spanish court has written on that certificate. Okay, then the recognition and enforcement of provisional measures. They cannot be recognized and enforced. This Pietro Francina has already said, so I can skip over this. So if you have based your jurisdiction on Article 20, those measures will be only for your country. They will not be exportable. As the regulation stands now, I have to say that, because the recast will bring some changes. Positive is the recast will bring better coordination between Brussels 2A and the 1996 Hague Convention. And now it's a very small, short provision. In the recast proposal, there are specific rules that make it much more clear when to use which one. Okay? The provisional measures, you'll only be able to take provisional measures if the child or property of the child is present in your country. So no longer on the basis that the parent is present in the country, only the child. Okay, they've moved this provision out of the general part and moved it into the part specifically on parental responsibility. So it wouldn't apply to divorce anymore. It applies only to parental responsibility cases, and it applies only when the child is habitually resident in your country. Okay, so it's only for measures in your country. Okay, the next ones, I've put question marks there because what I've written here is on the basis of the Commission proposal. Some of these things will change. Some of them, I don't know. There is a provision now for the recognition and enforcement of these provisional measures across borders, so that, okay, you've granted a provisional measure with respect to a child in your jurisdiction, the child then moves out, that provisional measure stays active and can be enforced across the border until the court of the habitual residence has actually taken a measure. I don't know whether that's going to be accepted. Will exequatur be further abolished? Yes, says the Commission. We'll see what the Council has to say about that. But they have built in a mechanism for the defendant to counter the enforcement. Okay, that doesn't exist now, but they've actually taken the Brussels I model, which says, okay, the measures are automatically recognizable and enforceable. However, a party can go to the court and apply for non-recognition and non-enforcement, okay, on the basis of the best interest of the child or any of the other grounds for refusal. There is more scope for direct judicial communication. That's a topic for tomorrow. More attention to mediation. That it's lip service to mediation, if you ask me, but I think you can discuss that tomorrow. And there are rules on the actual enforcement. So not only the cross-border enforceability, but the actual measures of enforcement in the recast proposal. But that is a very delicate issue because member states don't like the EU to interfere with the mechanisms of their national laws. So I don't know whether that will be accepted in the Council. Okay. I'm not doing very well on time, eh?
Well, we still have a small hour.
An hour?
Yes,
I thought.
You're not forced.
No, but I was really rushing. Okay, I was really rushing, so I don't need to rush. All right. International child abduction then. This, I've also divided this part into 6 sets. First we'll look at definitions, then the specific legal texts, which I've already referred to, but I'll look into more detail. Then at the legal procedures with respect to child abduction. And then a specific attention maybe where there are assistance for judges. Okay, the best interests of the child, and here we'll look also at the human rights context, and then I'll also look at what the recast aims to change in this respect. Now, the recast proposal is not proposing any changes on divorce because the issue of same-sex marriages is too sensitive, but all the attention has been focused on parental responsibility and how to really enhance the effectiveness of these procedures, and fortunately to enhance also the human rights of children, the best interest of the child, the hearing of the child. There's been a lot of attention to that by the Commission in the recast proposal. So what is a child abduction? It is the wrongful removal or retention of a child, and wrongful means in breach of custody rights of the other parent if these rights are in effect exercised. Yeah? So, the convention is called the 1980 Hague Convention on the Civil Aspects of International Child Abduction, but for the rest in that convention you don't really read the word abduction. It's always wrongful removal or retention. There is a bit of a debate also about what we should call this. There are those that say we shouldn't call it abduction because it's a very negative word which tends to polarize the emotions even further. It tends to victimize, well, not victimize, but to really point to the mothers as culprits. You are an abductor, you're a bad person. Well, on the other side, there are people that say you should not reduce the the crime that this actually is. Okay, you are committing a crime against the child, and in many legal systems it's also considered a criminal offense. So why not use a strong word for a strong bad action, right? Okay, I'll leave that up to you which words you would like to use, because as I say, one is in the title and the other words are in the convention itself. Right. So in breach of custody rights of the other parent. It is in about 97% of cases, well, according to research that we did in Belgium, it is a parent that removes the child. But it can also be somebody else. It can be both parents together. We had 2 cases where the 2 parents abducted the child from an institution where the child was placed. Okay? Or it can be an aunt, it can be an uncle, it can be a grandparent that abducts the child. The important thing is actually that the left behind person was a person with parental responsibility or custody rights, and those custody rights were not respected. Can we use the convention if the child is abducted by a foreigner? The convention doesn't prevent that, right? But why would we do that? The purpose of the convention is to restore the family situation, to return the child to the family to the habitual residence, and then sort out the family situation. While if a child is abducted by a third person, we're going to put all the effort into criminal proceedings and to get the child back from the, not to try and cooperate with this person, right? Custody rights. So here we get into all sorts of legal definitional issues, because remember the convention was concluded in 1918. So they were really thinking in terms of custody for one parent and access for the other parent. Nowadays, in more and more legal systems, you have a situation of equal custody or equal residence. We don't really use the terms custody and access. We use contact and care, or parental responsibility, or residence, first residence, main residence, secondary residence. But fortunately, the convention defines what it means by custody. So even if your legal system doesn't use this word anymore, we can see what we mean. When we mean the right to decide for the child, amongst other things, and this is the important thing, amongst other things, the right to determine the child's residence. Okay? So it doesn't matter what you call it, who has that right to decide where the child will live, that falls under custody. Custody can be created by operation of law when the child is born, which parents have parental responsibility, have custody, or by an administrative or judicial decision, or by an agreement with legal effect. And here we're talking about a kind of mediation agreement, for instance, or a mediated agreement that has been notarized or has legal effect. Okay. The power of this convention is exactly in the broad recognition of custody rights, also if it is by operation of law or by agreement, because other conventions require there to be a judgment that we then recognize in order to speak of an abduction. But this convention recognizes, but there can be an abduction even if there had never been a judgment. And that's very often the case. Okay? There's not a judgment, but there's shared parental responsibility, and one parent then takes the child away. This convention introduces a mechanism for that, even if there hadn't been a judgment before. So, the legal texts. Brussels 2A and the Hague Convention are the most important ones. Which ones do we use? Well, we see where the abduction took place. If it was from one EU member state to another EU member state, let's say now from the Netherlands to Romania, we're going to use Brussels 2A and the Hague Convention together. Okay? If the child is abducted from the Netherlands to Moldavia, so it's from an EU member state to a Hague Convention state, then we're going to use only the Hague Convention. The other way around as well. From Moldavia to the Netherlands, only the Hague Convention. Even if the child is abducted into the EU, we're only going to use the Hague Convention. We're not going to use the extra mechanisms of Brussels 2A that I'm going to refer to just now. For other states, if the child is abducted to a state that is not party to this convention, then we can only look at bilateral conventions or diplomatic solutions. Now, the Hague Convention is actually aimed at, as I've said, the immediate return of the child. Okay, it's a kind of like a provisional measure, almost like a big provisional measure, saying, okay, the child must go back, and then the custody dispute or the residence dispute or parental responsibility dispute will go to the judge of the habitual residence of the child. Yeah. However, first of all, there are 98 contracting states of this convention, including all EU member states. So it's a big, broad convention. But you cannot just use any of the contracting states and think that you can apply the convention. Okay? Because, I can put the water here, and that's very clever. So, when all the member states of the Hague Conference negotiated this convention back in the 70s, they said, yeah, but it's a bit of a danger as well, because we're all agreeing to send children back. And who knows, tomorrow some country that is in war and that we don't trust, some rogue state, wants to accede to our convention, and then we have to send our children back there. So they said, okay, we're going to include this, what they call in international law, bilateralization mechanism. And this means that when a new state joins, not us that are sitting in the room back in the 70s, not the people that were there then, but if new states join, like Guatemala or Pakistan or whoever, then the convention will only create obligations between that new state and states that have accepted its accession. Okay, so if Russia joins and we say, no, but we don't want to send our children back to Russia, we don't accept its accession, and we just function still outside of the convention rule, right? Of course, it goes both ways, because then we don't have bilateral relations with Russia, so we're not going to send children back, maybe, but they're not obliged to send children back either. So that goes both ways. But what happened then in 2012, 2013 was a dispute between the EU and the member states, because then, and it was specifically with regard to Russia. Russia acceded to the convention, and then some of the states close to the border, like Estonia and I think Finland, quite soon said, okay, yeah, we're going to accept Russia, because, yeah, there are many citizens traveling back and forth, and it is useful to have this convention to make sure that children are sent back. So then the European Union said, wait a minute, you can't do that, dear member states. Remember, we have such a thing called the European Union, and the European Union has such a thing called external competence. And you might have just learned that in your law studies long ago, but it's actually not theoretical, it's actually very important. Because when something is the competence of the EU member states cannot go around and conclude bilateral and multilateral conventions any way you want. It's up for us to do it. Moreover, if it's for us to do it, being the EU, it has to be approved by Council. Moreover, Council has to approve it in family matters unanimously. So we can only have relations with Russia if we all agree, right? So that's where we stand now. For new states that are joining, it is for the EU to accept that accession. I mean, the positive side is obviously that we have one system in the EU. The negative side is that it takes a lot of time. There are countries like Pakistan who has joined, who is not, the countries that have joined in the last 2 years have not been accepted by the EU. So it's great that they are party to the convention. It's great that the Hague Conference did all this work to convince them, but we can't use it, okay? So we have to wait for the EU to take those steps. Okay. Are there any questions so far? Are there any? Yes. Yes. Okay. The table.
Yeah. Okay. You perhaps repeat the question.
Maybe can I use the microphone and then I can. then I can show you. That table is indeed the member states, but that table is unfortunately an oversimplification. So, oh no, I'm going to see. I hope this works now. You have to go to the specific convention, Child Abduction Convention, right? And then you go to the status table, which is that thing you have. But unfortunately, you see it has all these little stars. And unfortunately, these little stars mean you have to click on them. So let's take, I'm going to take Pakistan now to show you what I mean. Pakistan. The fact that it's in italics, that's just because it's not. The fact that it's in italics is just because it's not a member of the Hague Conference on Private International Law. So that doesn't matter too much for our purposes. So we're going to see. Okay, it acceded. That little star means so you have to check who accepted the accession. So you go there, and you say, oh dear, only Ukraine, New Zealand, Andorra, Brazil, Argentina, and Venezuela actually accepted Pakistan. So in the EU, it's for our purposes as if Pakistan is not, a contracting state. So the status table is correct, but you have to go online and check the little asterisks to make sure it applies to us, right? I'll take maybe another example to show you that it's not as bad as I'm saying. In all cases, so let's take the Russian Federation. Okay. Oh, okay. Estonia, France, Greece, all of them fine. Then you can see here. Okay, which country? I'm from Italy. Yes, fine. We have accepted Russia. Yeah. Sorry. This is the Hague Convention of 1980, the Hague Child Abduction Convention. Sorry? Russia's okay. Russia's okay. Yeah. So, sorry, I went maybe a bit too fast in the beginning. So we go, okay. This is the home page. You go then to the child abduction section. And here you have loads of information. All that information is actually quite useful because it tells you the status table, it tells you which are the authorities in the other states. It has conferences, special commissions. Oh, this is a touch screen, I'm sorry. It has statistics, case law, all sorts of information here. And one of the things it has is the status table. And on the status table then you get that document that you've shown me, and in that document you get the little asterisks. Oh, wait. So this is where we were. Are there any other questions on that? Okay. So it's just a little caveat. Incadat and Incastat, those are also on that website that I've just shown you. I've shown you there's a part that says case law, or you can Google Incadat. It is for International Child Abduction Database, and they are collecting cases on the application of the convention. The purpose is to see to the harmonious application of the convention so that we all interpret Article 13 in the same way. There is an English summary for each case, so it's quite useful. Unfortunately, due to lack of resources, they have kind of stopped uploading many cases there, so it's two reasons really. That merely staff-wise, the person who was handling it became ill, and there was not enough resources for somebody else to take it up. Incastat is where they collect statistics on the application of this convention. Then there are also all sorts of guides, a guide on preventive measures, which I think is quite important for judges as well, because I think very difficult as well, because often you have people that say, yeah, but can you ask him to leave the passport every time he takes the children, or can you take these measures? Can you give a measure that this person is not allowed to leave the country. And as a judge, I think it's the very important, very difficult weighing up the balancing of respecting people's free movement, but seeing where there's a real risk of child abduction. But how do you know whether there's a real risk or whether one person is just trying to irritate the other one or is making a drama of something that isn't a drama? And there have been cases where, they were not preventive measures and then the child was abducted. I'm sure there are cases in the other way as well. So there's a specific guide on preventive measures. How do we use those measures? There's a guide on mediation, on central authority practice, implementation, and they're busy with the guide on Article 13b, the draft guide. Well, there is a draft guide. The final version will probably be finished in a year and a half from now, so it's quite long still. But as I've said, the Hague Conference is very understaffed. And Article 13b is one of the big grounds for exception of return. I'm going to get back to that Article 13b. There are also commission documents. So every 5 years, the Hague Conference organizes meetings where mainly actually not policymakers, mainly actually the civil servants, people of the Ministries of Justice, people of the central authorities and NGOs go and they assess the operation of the convention, and they consider good practices, bad practices of the convention. They then write recommendations. The last one was in October of this year, so it's very recent. All those recommendations of the special commissions is on the same website. Very useful. And then they also have biannual newsletters, but again, they haven't for the past 2 years published a newsletter because they're very understaffed. But those newsletters are actually specifically geared for judges, so they're very useful when they're there. All the old ones are online. Right. So, what does Brussels 2A do? Well, okay, I've already said this, but it is covering the whole area of international parental responsibility and divorce, and also as a part of it, just as a subpart, child abduction. All EU member states except Denmark, we already know that. What it is a supplement to the 1980 convention. So what happened was in 2000, the member states were negotiating to make this regulation, this Brussels 2A regulation. And they had a big discussion about should this regulation, which will cover divorce and parental responsibility, also cover child abduction, right? Because you had a number of member states led by the United Kingdom and Germany saying, we have a convention. The convention is fine. So don't make things more complicated. Leave the convention and Brussels 2A will regulate all the other things, but not child abduction. Then there were the other states led by France, and Belgium was also part of that camp, saying, no, this convention doesn't work well. These Germans never send the children back, and they were saying all sorts of things. So we need a new mechanism, really. In the EU, we need something new because this convention is not good. I think part of the problem is also that the success of this convention is very often measured by how many children are sent back, as opposed to are the correct children sent back? Because there are grounds for refusal. Certain children you can't send back because it's dangerous. And just looking at how many children we sent back is not a true picture of the functioning of the convention, right? So anyway, these member states were saying we need something new in the EU because this convention is bad. Then it became very heated and they had a big fight. And then they decided, okay, let's compromise. Compromise is a good thing, you would say, but in this instance, it made things rather complicated. Because what they said is we'll keep the convention, but we'll also add a European flavor to it. Okay, so we'll give the Germans and the British what they want, namely we'll keep the convention, but we'll also listen to what France says, namely we'll do a bit more in the EU. Okay. So this is why we have to apply these two things on top of each other, and that's why it's quite complicated. Okay. And basically this supplement does two things. It enhances the goal of return. Okay. So as I've said to you, some of the commentary is, well, not enough children are sent back. So the EU is going to send more children back. Others, on the other hand, there is restricting the grounds for refusal. Okay, because some of the grounds for refusal, and that's probably true, were used very often, and the EU wanted to restrict the use of those ones. Okay, I'll show you the exact rules just now. And then it fits child abduction into the rest of Brussels 2A by saying that the fact that there's a child abduction doesn't move the jurisdiction. Okay, so even if there's the child has a new habitual residence, if that habitual residence came about by child abduction, then we're still going to use Article 8 and 10, as I've just explained to you. That's just how this Child Abduction Convention fits in to Brussels 2A. We see the same logic in the 1996 Hague Convention. Okay, that convention also says, well, if there's an abduction, then you don't have a shiftless jurisdiction because you first have to go and solve that child abduction issue under the other convention, the 1980 convention, and then the 1996 convention will apply with respect to the substance of the matter. Yeah? There is also the Luxembourg Convention. That's a convention by the Council of Europe. And that convention is less used because in the EU it is superseded by the Brussels 2A regulation first. Second is it only applies when there is a judgment. So as I've said to you, the big advantage of this Hague Convention is that it doesn't require a prior judgment. Well, the Luxembourg Convention does. It says, well, if there's a judgment that says that the child must be every weekend with the father and the mother then takes the child away, okay, that is contrary to the judgment. Okay, so it's much more specific. We have the 1996 convention that kind of fills the picture. And then also there can be bilateral conventions in your countries. Don't forget the human rights network around that. We have the European Convention on Human Rights that I've referred to in the beginning, specifically the right to family life and the procedural rights, right to a fair trial in Article 6. Those two articles have been invoked often in child abduction cases. The European Court of Human Rights has granted several judgments on child abduction, and it's always one of those two articles that is used. And the Article 6 one, that specifically is about the timing of these proceedings, okay? I'll come back to the timing. We have the Children's Rights Convention. Those are the three important provisions for this field. The best interest of the child, and that is also something that the European Court of Human Rights has referred to. The best interest of the child must be considered in every case that concerns the child. Okay. Then the child has the right to have contact with both parents, and the child has the right to be heard. Okay. In the EU Charter, we see those same obligations coming back. Article 7 of the EU Charter is very similar to Article 8 of the European Convention of Human Rights. Article 24 of the Charter is similar to the Article 3 and 12 of the Children's Rights Convention, so it's really various aspects of children's rights, and Article 47 is about procedural rights. That EU Charter, as I've explained to you, applies when EU law applies, but as we're talking about EU law, it applies in this matter. Yeah. The Hague Convention of 1980 has the rule that if the child has been removed, wrongfully removed or retained less than a year ago, the child must be returned. Okay, that's the rule. If it is more than a year ago, the child must also be returned unless the child has become settled in the new environment. Okay. That rule is what the convention says. That's the core of the convention, and that is taken over, well, not taken over, but it's actually referred to by Brussels 2A. The court must decide within 6 weeks, okay, which is the very difficult part because yeah, you have to do this assessment, and it has to be done in 6 weeks. And it also depends on how the judiciary is structured in the legal systems. Some legal systems have concentrated jurisdiction, so it's only a few courts that can hear these cases. I think, for instance, in the Czech Republic, there's only one court that can hear these cases. Yeah, only one in Brno. Yeah, in Belgium we have 6, so we have kind of concentrated jurisdiction, but not as concentrated as in the Czech Republic or as in the Netherlands, where they also only have one case. In France, they have quite many. Why am I saying this? Because that would make it easier for a court to stick to that 6 weeks period, because the judges would know, okay, I'm always dealing with these cases, and this is how my role works, and this is how my work is structured, right? Well, if it is in a general court where you can get all sorts of cases, I think it can be more difficult to keep to the term. And also a judge it might be the first time that you have a child abduction case, and you have to find all the sources, and it takes longer than if you do this every day, because, yeah, right? Okay. Sorry, are there any questions on that? Yeah? The Hague Convention, as I've said, contains exceptions, okay, because there are some instances in which we can't send the children back because it's dangerous, right? The first is if the applicant was not exercising custody or consented, okay? So there's a case where the mother took the child from Israel to Belgium, and the father consented. There was even a funny little story in the newspaper about the cat that was gone, and then the father helped them to look for the cat, blah, blah, blah. And then after a year, after a few months, he came and said, no, this was an abduction. No, because you've consented, so we're not going to send the child back, okay? This is the Article 13b one that's very often used. That is if there is a grave risk for the child of physical or psychological harm, or to become in an intolerable situation. Very difficult, because very often domestic abuse is alleged while it's true or not true. Very difficult also because, now remember, what the judge has to do is assess a situation in the other country within 6 weeks. So within 6 weeks you must decide whether this allegation of domestic violence is true or not. Why didn't you go to the police? Or did you go to the police? Where are the police reports? Well, they're in the other country. How can I get them, right? So very difficult, I think, in practice to make the correct call there. The next one is if the child objects and the child has attained the age and degree of maturity where it is appropriate to take account of his or her views. Okay, this was actually written for 15-year-olds, where it's a bit difficult to force a 15-year-old to go back. The 15-year-old has decided, I want to live in this country. However, okay, I'll come back to that when we're talking about the Brussels 2A regulation. Then there's also Article 20, which is fundamental principles of human rights and fundamental freedoms. This is a very extreme ground for refusal. It is where we know if we send this child back, he's going to go and work in a factory and make clothes for Western shops. We're not going to send the child back if we know that, right? Not often used, but it's important that it's in there. I think it's also important when we consider agreeing to the accession of countries like Pakistan, where we know there might be child labor, but if we have this, then we can, in a specific situation, assess the circumstances of this particular child. Okay. So what does Brussels 2A say? It says the same thing. In Article 11, it says, okay, we're going to use this Hague Convention, so we're going to send the child back. That's the rule. Yeah. However, we are going to enhance this a little bit, as I've said. First of all, the child must be heard unless the child is of an age and degree of maturity that makes such hearing inappropriate. So they've turned it around, a stronger obligation to hear the child. Why? Well, I think, remember the Children's Rights Convention dates of 1989. So the Child Abduction Convention is actually older than the Children's Rights Convention. Okay, so here they're bringing Brussels to a more in line, not entirely in line, but more in line with the Children's Rights Convention. Why am I saying not entirely in line? Because we'll see in the recast, they're changing the wording even more to be more in line still with the Children's Rights Convention. Okay, because what the Children's Rights Convention says is that a child has the right to be given the opportunity to be heard if the child is capable of forming such view. Then due weight must be given to whatever the child said on the basis of the child's maturity and age. Okay. So, while here you can refuse to hear the child because the child is not mature, the Children's Rights Convention actually says, well, you must hear the child and then decide on how much weight you're going to give to this. This is a very complex topic which sociologists and human rights lawyers debate a lot about. How do you assess maturity? How do you decide whether a child is mature or not without having heard the child? How do we as judges hear children? We're not psychologists or sociologists or educational scientists. So how do we actually do that? Very different in different countries as well. But you'll hear more about that tomorrow, right? That in some countries the judges hear the children themselves, and in other countries they have an intermediary, a curator ad litem. But okay, you'll discuss that tomorrow. What Brussels 2A also says is you must use the most expeditious national procedure. Whatever that is in the legal system, the idea was that the national legislators transposed that into national law. In some countries they did, in some countries they didn't, but the idea is that it is the fastest possible procedure. And the 6 weeks have become compulsory. Okay, so under the Hague Convention there was a right for the central authority to ask, well, why are you taking so long? Can you please explain the delay? Here the regulation says you have to decide within 6 weeks. The convention's exceptions also obviously apply. So if the child, if there's a request for return, we're going to see what are the exceptions, but they are also, as I've said, restricted. First of all, that Article 13b, that very contentious one, if there's a risk for a child, the judge also has to assess whether that risk can be addressed in the country of habitual residence before refusing return. Okay, so under the Hague Convention says you can refuse the return if there is a risk of an intolerable situation or psychological or physical harm to the child. The regulation says no, but before you refuse, you have to see whether they cannot deal with that issue over there, whether they can maybe have supervised contacts for the father. I think also quite difficult to deal with in 6 weeks, but tomorrow you're going to learn more about direct communication between judges and with central authorities. I think they're crucial here, because how do you know whether in the other country what measures are possible? Okay, and there can be no refusal if the applicant was not heard. Now, the applicant is the left behind parent, right? The mother took the child from the Netherlands to Romania. The father is the one requesting return, but he's in the Netherlands. He must be heard. How he is heard, that depends on whether you use Skype or video conferencing, or whether he or she comes. That is, you can use the evidence regulation there. That is, there are different options. Then, if return is refused under Brussels 2A, there is a second chance, called the second chance procedure, or the trumping procedure, or sometimes called the overrule procedure. So what happens is, the child was abducted from the Netherlands to Romania. The Romanian court said, but there's a risk for this child. They're in the Netherlands, they can't address this risk. So I'm going to refuse the return of this child. Then the Romanian court has to send that file to the Dutch court. and say, okay, I'm sorry, but we refuse to return the child. You can have a look at the file. And you can reassess the situation. You can re-decide. What about mutual trust? Doesn't apply here. No mutual trust, okay? Don't have to trust what the Romanians did. We are going to reassess whether this child must come back, okay? Then, so the Dutch courts can decide again. Then, we're going to come into the enforcement of that judgment. That's going to be difficult. But before we do that, help for judges. In the convention itself, the Hague Convention says that a judge may take judicial notice of foreign law. So, in national law, sometimes it's the judge's obligation to find foreign law in most civil law countries, but in most common law countries, it's the parties that must prove foreign law. This is just an extra help, actually, specifically for countries where this does not apply, that a judge may take judicial notice of foreign law. It helps you to go quicker. If information is needed on the parental responsibility in the other country, you can ask for a declaration from a court in another country on the parental responsibility situation. Okay, so there's a child here, this child in Romania, but we don't know whether this father had actually parental responsibility. We can ask for the Dutch court to give us a declaratory judgment. There is a bar on custody decisions. So, the child that went from the Netherlands to Romania, the mother now goes to Romanian court and said, I would like this child to remain with me, please. Then the Romanian judge will say, wait a minute, why is this child here? Do I have jurisdiction? I don't have jurisdiction. Article 10. So, in order to echo that, the Hague Convention also says you cannot take custody decisions at the moment. So it's really, see, they all work well together. There is the Hague Network of Judges. I think you're going to hear more about that tomorrow. There's also the EJN. You'll hear more about that tomorrow. All right. Now, we come to the issue of the best interests of the child. It is underlying in this Hague Convention, okay? You'll see if you read the preamble that it says it is not in the interest of children to be taken from one country to the other as if they were cattle, right? So we want to counter international child abduction. And how are we countering it? By educating people and teaching them and showing them that if you take your child from the Netherlands to Romania, it's not going to work. This child is going to return because it's a Dutch judge that has jurisdiction, right? That's what we want to achieve here. However, the European Court of Human Rights, as I've said to you, have granted many judgments, and they have said, yeah, but in order to respect the rights of children and in order to respect family life, we have to take into account the best interest of an individual child. You can't just say, it is not in the interest of children to be abducted, and therefore all these children must serve this higher goal. We must look at the individual child. This caused a great deal of commotion because the whole purpose of the Hague Convention is not to do an assessment of the entire family situation. The whole purpose of the Hague Convention is the Romanian court saying, I'm sorry, we can't deal with this, go back to the Netherlands and deal with the whole situation there. Go and assess the child's interests there, go and assess what the parental responsibility and the custody and the access and the contact and all the other arrangements should be over there. And we have only 6 weeks. It's just a provisional measure. But at the same time, the European Court of Human Rights says, yeah, but you have to look at this particular child. Now, the cases that have gone to the Court of Human Rights are cases where it's taken very long. The Neulinger case, it dragged on for 8 years, okay, if we start from the very beginning. Then you had the Swiss national cases. Then it goes all the way through the Swiss legal system. Then it goes to the European Court of Human Rights. Then it goes to the Grand Chamber. The case was stuck in the European Court of Human Rights for 4 years. Okay, is it now in the child's best interests? Maybe not. So what the court then said in X versus Latvia, the court try to strike the correct balance between the best interests of the child and the Child Abduction Convention by saying, okay, this Hague Child Abduction Convention aims at getting the children back. Every time that a child is involved, the child's best interests must be taken into account, but within the context of this Hague Convention, not an entire assessment of the family situation, what is going to be best for this child for the rest of his or her life. No, just in this particular context of you have to now go back, and then they will determine the issue over there. I think very difficult also for a judge to be able to hear the child, and hearing the child, I guess, also discussing the issue with the child and trying to explain that, especially because the systems go so slowly. Because even if, let's assume now you manage to do this in 6 weeks, then the child goes back. Then the case gets into the roll there in the Netherlands. Now, in the Netherlands, they're pretty efficient. But still, they're not going to have a judgment tomorrow or within 2 weeks. Okay, you're in the roll. The Dutch judge then says, oh yeah, well, actually, maybe it's a good idea that the mother can move to Romania and we can find an arrangement, and the child comes back every holiday, whatever, or the father goes and visits the child, what? Now the child has to go back again. So you can see in the child's eyes, it's just like going back and forth between mom and dad. Actually, not between mom and dad, but between country and country. So the big solution that has been proposed here by certain scholars, but also by MIC in Germany and by Centrum ICO in the Netherlands, is to work on mediation here, and also in family law chambers, for judges to refer the cases to mediation, or for judges to try and find a solution, depending obviously on how your national system works, for judges to try and find a solution that is really carried by the parents. So yeah, it's a difficult balancing act between very short time, making a proper assessment, taking into account the best interest of the child, but not a full assessment. An appropriate but not full assessment. And then the difficult balancing act is also the prevention aspect. We want to show people that you can't just abduct your child because we have a law, we have a legal system, and you're going to have to go back. But also taking into account this particular child's situation. Are there any questions or comments on that? Yeah. Okay. What does the Brussels 2A recast bring? Well, it brings clarity on the timing. So this is again talking about the Commission's proposal. I'm not sure whether these issues will be accepted by Parliament and Council. The first two, I think all three of them will probably be accepted by Parliament. The middle one, I'm not sure whether that's going to be accepted by Council, but let's see. The timing issue, a question that arose here is, okay, we have 6 weeks, but what about the appeal? And there were different views about whether the 6 weeks also applies to the appeal, or whether it applies to everything condensed into one. And now what the recast says, it is 6 weeks per instance. So 6 weeks at first instance and 6 weeks on appeal. Maybe it's a step back, but in most cases it's not a step back, because now it's clear that the 6 weeks also applies to appeal, and it's clear what we mean. Then the hearing, they're saying that the child must be heard in line with the Children's Rights Convention. So that's what I explained to you earlier, that this convention has a difference between hearing and assessing maturity. The recast has taken that over. Parliament, I think, is in favor of that. What is interesting actually here is that the Petitions Committee of the European Parliament proposed inserting an age. And they said that children must be heard in any case as under 12 and as of 16 years of age, which doesn't apply to child abduction cases, but in other cases, as of 16 years of age, the child's view must be seen as decisive. the Commission did not want to include an age limit because children's rights experts also say you shouldn't put a numerical age. You should assess the maturity, right? Can a child, because some children, especially children that go through trauma, can be much less mature than their peers or much more mature than their peers because of what they've gone through. And I think also Parliament is not going to accept what the Petitions Committee wrote here. I've heard that it's rather exceptional for the Petitions Committee to actually propose legislative amendments, but the Petitions Committee, of course, have had many petitions by parents who were unhappy of the functioning of this regulation. So they have interfered, or they've tried to interfere, but I don't think that an age limit will be written because it will be very, very difficult to accept in Council, because some member states hear children as of 12 or 14. In Germany, they hear children from 3 years old. So it will be very, very difficult to accept that in Council. Then they want to make the second chance procedure more efficient by the way in which documents are sent across, and also by inserting time limits for the second chance procedure. Yeah, because that's often then a problem as well if that takes too long. That is the entire story of Brussels 2A. I should maybe just add one more word about the enforcement, because when I referred to the certificates, I said that there are two types of certificates, and I said that I'll come back to that. The second type of certificate is the certificate after the second chance procedure. Okay, so in our situation, the child went from the Netherlands to Romania. The Romanian court said, no, the child must not go back. The Dutch court then said, no, the child must go back. Right? That's a second chance procedure. That second chance gets a certificate, and that certificate must be accepted by all member states. In the recast, there might be, well, that's now proposed, that there is a possibility to request the non-recognition. Okay, so that will be a new procedure in Brussels 2A, which will come to the judges, of course. Requests for non-recognition, and they will come. I'm sure they'll come, because parents keep on fighting about these children. So let's see what happens in the Brussels 2A recast. Thank you.
Thank you very much, Thalia, for this clarification of what seems to be, well, for me at least, and at first glance, perhaps rather complex rules. But I'm quite certain that the rules will become even more clear once we start applying them. And this is what we're going to do in this second stage of the afternoon. We're again in small groups going to try and solve a practical case. But before doing that, Mirjam de Hemtin has asked to give a short introduction, to give you some guidelines, to be able to solve the case quite quickly. And this offers me the opportunity to introduce to you our third expert of today, Mirjam de Hemtin, my colleague from the Court of Appeal in Brussels, who serves in the Family and Youth Chamber. She's also a member of the Hague Network of Judges, member of the EGN. And so she has first-hand experience in dealing with cross-border family law cases, and she's kind enough to share this experience with us today. Thank you, Mirjam.
Thank you, Ilse, for these kind words. I think we all are judges. We need some easy think patterns, and after all this very comprehensive and interesting explanation, I just wanted to share with you two little schemes that I've made to help you in your thinking patterns when you are at first hand in a cross-border case. So my first, and I think I showed you this today now because you can use it after in the case study, in the case work that we're going to do after the break, the coffee break. So this first slide is, can you see? Yeah, the question is, what basis what legal instrument am I going to use? Okay, so it's quite easy, but I think if you can already have this, it will help you. if the first question to ask is the habitual residence of a child in an EU member state. If the answer on that question is yes, you just go and plonger. How do you say it? You dive into your regulation Brussels 2A. If the question on that is no, then you ask a second question: is the habitual residence of the child in a non-EU contracting state of the Convention of the Hague 1996? And so a non-EU contracting state, as Thalia told, for instance, Turkey, Morocco, Switzerland, Norway, yes, which are all quite usual states where we work with. So, okay, if the answer on that is yes, okay, you dive in the Hague Convention. If the answer on that is no, you go back to your regulation, and in the regulation you will have the solutions, which will lead you maybe further than this instrument. But take again your regulation. Your regulation is you are all European judges, and the regulation is your first instrument that you have to take in hand. And the next slide is then the one that will tell how are you going to reason when you're looking for this jurisdiction matter under Brussels 2A. So you will verify the different bases as we've been talking about, Article 8, 9, 10, 11, 12, 13 especially, 12 and 13. 8, 12 and 13, these are fundamentally the most relevant articles. If the answer is, okay, I can take jurisdiction on this matter, and you have only to ask whether you have this jurisdiction, you don't have to think about a foreign judge having or not jurisdiction. This is sometimes confusing, because we sometimes are confused in saying this other judge should do this or that. No, it's only about your work. So do you have jurisdiction? If the answer is yes, okay, you go and exercise your jurisdiction. You go ahead. Or you can transfer the jurisdiction to a better placed, a court better placed. We will speak about that. We have spoken about that. We will repeat tomorrow. I think in this matter it's not bad to repeat some things. So this alternative exceptionally is Article 15, transfer to another court. But mainly is exercise your jurisdiction. If you have no jurisdiction yourself, then you have to have the second step and ask yourself, is there another member state, EU member state, that has jurisdiction under Brussels 2A? And if the answer on this question is yes, then you stop and you just say, I have no jurisdiction. You do not transfer the case, you just stop. You don't go further. If the answer on the second question is no, that means not yourself, but no other EU member state can have jurisdiction, then you can go further, and you can go, and you will see that in Brussels 2A, Article 14 will tell you, then you can go maybe in your internal PIL law, your private international rules. And then you can again assess whether maybe under broader rules, other rules, you may take this jurisdiction. And if this is the case, then you go ahead and you exercise your jurisdiction. Or, again, you can transfer to another EU state or to another Hague state, contracting state under the Hague Convention. And if the answer is no, then again, you stop and you do not transfer anything. So, okay, this is a very simple scheme, but I think that this can help you if you think this doesn't solve all the problems, but I think it's a good pattern to think. Okay, I suppose we are going to break.
Yeah.
You will have this case study after the coffee. I suppose Sarah will explain again how we organize that. Just to tell, I prepared two cases. I prepared one, and Thalia gave me another case, but I think we will not have the time to do both. So I suppose you can take both with you, but let's try to work on one of them. This is the one with Maria and Carles, the two Spanish nationals. Let's work on that and speak about that after discussing in little groups. I have 4 questions. Again, as a case study of this morning, there are open questions. You can imagine, make assumptions. The second question is, what information do you need? And if you have determined the information that you need, you can assume, okay, if we have this information, then I would do this. If I would have this other, if it's the facts are this or that, I would do that. So the third question, which rules are applicable? It will be in function of the different situations that you will maybe imagine around this case. And then I have put a variation. The parties are not living in Paris but in Casablanca. I assume then that everything is going on in Morocco and not in France. So it's very short, but you have to assume all the situation which happens in Morocco and not in France in that case. And then you think about what would change. Thank you.
Okay, thank you very much.